Hi, my name's Karen Holden from a City Law Firm, and I want to talk to you today about when you become partners to rivals. So how do you protect your company when that happens? And my position is restrictive covenants. It's a very dry, boring subject, and as a lawyer, I'm afraid I'm talking doom and gloom, but hopefully with the right advice, we can actually mitigate these circumstances. So today we're going to tackle an issue that genuinely can make or break your business. Restrictive covenants. What's their role? How does it protect your company during shareholders, directors, or even staff disputes? And we're going to touch on the importance of how these should be incorporated, whether it's in your policies, contracts, and what should be included. I'll try to make this as exciting as possible. Restrictive covenants are clauses in contracts designed to protect your business from those who know it best. So they know your trade secrets, your clients, suppliers, confidential information, maybe your marketing secrets. These are your directors, shareholders, founders, and key employees, particularly client managers and managers of your teams. These covenants are actually there to protect them from walking away with your clients or staff, setting up in competition, taking trade secrets with them. Now, without restrictive covenants incorporated into your policies and contracts, when a relationship turns sour, and sadly it will do at some point with somebody, it does leave your company vulnerable. Now, whether it's a co-founder leaving the company or a senior director moving on or a member of staff moving on, they can take with them valuable knowledge, contacts, even influence, potentially convincing rival businesses to poach your team or clients. We have to deter them from doing so. So the importance of a restrictive covenant, let's take it for shareholders, directors and senior staff, for example, because that's where the stakes are much higher. We have to have restrictive covenants for these individuals, and normally I'd say between 6 and 12 months. Shareholders and directors, you can actually typically go above 12 months. For junior staff, those that don't hold full confidential information and trade secrets, I would probably say the average is 3 to 6 months. You have to be very careful that you don't make them too restrictive, or they can be unenforceable. So we do need to look at what is essential to protect your business. Now, they need to be clear and they need to be reasonable. You can't stop someone working full stop, because that's called a restraint of trade. So you can't just stop someone working in London if they're not competing directly with you. We can't stop junior employees for 12 months working for a competitor if they didn't really have that much exposure to your clients. We need to have a look at what the actual conflict is, what potential loss there is to you. And if they're generally competing with you or taking clients, then that's a different story. So what kind of types of restrictive covenants would we be looking at? Well, you'd have your standard non-compete clause, preventing someone from setting up their own business in competition with you or joining a competitor within the geographical area. And that's particularly key for senior staff, directors and shareholders. You'd have non-solicitation clauses stopping them from approaching your clients and employees, but also potential clients that you've been nurturing for the last 12 months that they've had exposure to. You'll have non-dealing clauses. This goes a step further, ensuring that they can't do business with your clients at all, because whilst they're working for a client, the client might not need you. So even if a client approaches them and they don't poach the client, we can even incorporate that. Then you'll have confidentiality clauses protecting your sensitive business information and your trade secrets. But it's not just about adding these clauses to contracts and hoping for the best. We need to make sure the wording and the legal framework of these restrictive covenants is carefully considered, because we need to make sure they're actually enforceable. Courts will strike them down if they're too broad, unreasonable, so we do need to tailor them specifically to your business needs. So creating and implementing restrictive covenants, we need to look at where we place them. In my opinion, you create a standalone policy that you can amend, but you incorporate into the employment contract or director's service level agreement or shareholders agreement that these are legally binding. This is where you give these to key members of staff. And as I've said, we make sure that restrictions are fair and within the right period, and therefore they're legally binding. When drafting these provisions, we do need to think about what period then would work. As I said, 12 months for director shareholder plus would be fair, but for a junior member of staff that would be too restrictive, so we'd probably err on the side of caution and suggest 3 to 6 months with you. We'd look at the geographical area, we'd look at the trade, we'd look at the sector, how involved are they with assets and clients and strategic information, and make sure that we propose restrictive covenants that are fair and reasonable and therefore enforceable. If they are overly restrictive, please understand that the courts can strike them out. And also, if they're incorporated into a contract and that contract is later found to be void, they'll argue so are the restrictive covenants. Hence why I'd suggest we put them in a separate agreement or policy, but then make them legally binding. Everything can be done in a legal framework that's sound and secure and enforceable. So look, in short, restrictive covenants are a very powerful tool. They protect your business, but they do need to be implemented with care. So whether you're dealing with a departing founder or shareholder, whether it's a director or it's just a member of your team, we need to save your company from future risks. And these provisions will really help you. So please get in touch. We're very happy to speak to you about these. We'd craft them and tailor them specifically to you, and we'd actually add them into your policies and into your agreements as necessary. Please, everything we do will stand up to legal scrutiny, we hope, and we'll do everything we can to help you. Thank you.